Good morning and welcome to our Labor and Employment, Ayrton Burles LLP Labor and Employment webinar. Thank you very much for attending with us on this rainy morning in Toronto. Our topic today is a very interesting one given the legalization of marijuana, compliance and liability in the area of cannabis, legalization tips, traps, and strategies for employers. We apologize for the length of that title. I think that took 5 minutes to say. I'm joined here today by my colleagues Michael Horvat and Fiona Brown. We're going to take you through not just the legalization issue, because the legislation is the legislation, but also some of the issues which will arise, and more importantly, some strategies to deal with legalization. The one overarching theme I think you're going to find in our presentation is, number one, we really do encourage a sense of everybody just taking a deep breath, pun intended, and taking a look at your workplace policies. So we're not going to overreact to that. But the second part is that there is no doubt that there are going to be more users that are entering the workplace. We know that statistically from experience in Colorado. So you're going to get more adults who are using that are now going to be employees doing something. So that's a big part of what we're doing. So we want you to think about. So today's agenda, we're going to look about current legal use, expectations when legalization comes in, the impact in the workplace and what might happen, how to prepare your workplace to the extent that many of you have not already done so, and policies, accommodation, training, and discipline. These are all really practical issues which have been raised with us as legalization has been impending. So we're going to look into the current marijuana environment in Canada, and for that, I'm going to hand this over to Fiona Brown. Fiona?
Thanks, Lorenzo. So medicinal cannabis has been legal for quite some time. However, cannabis is not an approved drug for prescription by doctors. There's no DIN. Cannabis remains a Schedule II drug under the Controlled Drugs and Substances Act. Medicinal use is based upon a medical authorization rather than a prescription. Regulations limit possession to either 30 times the daily quantity of dried marijuana indicated by a healthcare practitioner on the medical document, or 150 grams of dried marijuana, whichever is less. And access is currently limited to mail by way of the licensed producers, who are the growers of cannabis. Federal Bill C-45, which is known as the Cannabis Act, will be legalizing marijuana on October 17th. It allows for national recreational use by individuals 18 and older. However, provinces have the right to increase that age if they want, among other things. The Cannabis Act will allow for possession of up to 30 grams. Individuals are also permitted to grow up to 4 plants for their own use. Currently, the sale of edibles is not allowed by this legislation. It's anticipated that it will be permitted at some time in the near future. Individuals are allowed, however, to create their own edibles at home for their own use. Suppliers will be allowed to brand their products. That said, it's heavily regulated, in some ways very similar to the cigarette industry, in the sense that they cannot brand to appeal to youth, or they're also not allowed to sponsor events.
Thanks, Fiona. And what you will find that the legislation with respect to even the packaging is so restrictive, and advertising, very much, as Fiona says, like advertising tobacco. But the packaging, as you'll see, and it's still subject to the first packaging that we're going to see, is really restrictive. So it can't in any way be attractive to youth. And given the fact that you can do edibles at home, we're going to look for instead of lemonade stands on your side street, we're going to look for edible stands where kids are selling brownies. So that's the next topic we're going to hit. So, Michael, I'm kidding, by the way.
Thanks, Lorenzo. As Fiona pointed out, medicinal marijuana has been legal for quite some time, since 2001, but it's under a heavy restriction with respect to how it's both distributed and who can actually possess and utilize that benefit. Current stats show that only less than 1% of Canadians are actually registered for medical cannabis use. So this has been, as far as people who are following the rules, a very restrictive issue as it relates to actual permitted use under the medicinal category. However, even in this context, 11% of Canadian employers have already had to consider accommodation of employee who's authorized to use medical cannabis. So this is a number that's going to increase dramatically, we expect, with regard to employers who are going to have to deal with this, because it is not just about medicinal use, it will be about legalization. And a change potentially in current regulations regarding medicinal use will not change. However, an extra layer will have to be added onto this.
So I'm just going to back up one slide there. Thanks, Michael. And take a look at, just hang with me here, under the current marijuana use in Canada, illicit cannabis use, and this kind of follows well onto Michael's slide, it's large and well served. So we all know now that the black and gray market with respect to marijuana use, it has been over the last year to 2 years incredibly easy to get access to cannabis. And that's in all forms, whether it be as a result of edibles or just cannabis use, whether it's vaping or smoking. And we've seen, the storefront cannabis stores, which were raided a while ago, but really the police have stayed away from them. Drug dispensaries and doctors' notes, all of which have been incredibly easy to get. So use is there. And it's interesting, we don't know what the statistics are, but they're probably very high, and they're probably going to be about the same once we enter legalization. But one of the reasons why, and we listened to Anne McClellan, who was on the committee that was responsible about a year ago, the reason why the Liberals say that they brought this in was because they wanted to, it was already gray market, and they wanted to try to control the substance, particularly for how it gets to the youth market. But it really is a huge tax issue. In other words, this is a revenue source that the government has not been permitted to access, and now it is. So we're looking at 4% annual growth in production in tons over the last 7 years. So Michael, pick this up again.
Yeah, so we've got sale of recreational marijuana is set to begin across the country legally on October 17, 2018. 1017 for everybody, sort of the new moniker in Canada, if it actually happens. But every expectation is now that those regulations and the Cannabis Act will be put in place, and provinces have to catch up. So at that point in time, dried flower and oils will be available for sale. However, each province is entitled to regulate provincial use, similar to alcohol, which means that some provinces are further ahead than others. We'll focus on Ontario, but just note that British Columbia, Quebec, and other provinces are actually a step ahead as it relates to distribution and availability for cannabis products on October 17th. With respect to Ontario specifically, the minimum age to purchase is going to be set at 19, so this is the same as alcohol. The use right now is very limited to private residences only, so there is no ability or legal right, even in a recreational sense, to be able to use marijuana at a club, at a entertainment establishment, at work. It is limited to porch, backyard, and even as it respects balconies, and this is multi-use dwellings, even then you could be subject to your own condo and apartment regulations as it relates to smoking and public use of cannabis. So we're talking about significant restrictions here. So any public space and motorized vehicles are going to be prohibited. So no one sitting in the parking lot in a private vehicle of your work establishment is going to be permitted to use recreational marijuana. It had intended, at least the Liberal government, previous Liberal government, had intended to monopolize the sale of marijuana in the province through the Ontario Cannabis Store. That now has been that plan's been derailed by the election and the election of Doug Ford as premier. There's a focus now on trying to get a private enterprise to take up most of the sale in Ontario. That being said, the province is still going to be the only wholesaler as it relates to distribution, and as of October 17, all Ontario can offer is online sales. There are going to be an expected retail network, but that's not likely to happen until April 1, 2019, and we actually don't know what that is going to, there's no regulations around how that's going to take place.
Yeah, and it's a good point, and Fiona and I have been to many conferences. We're in the firm's cannabis group, and one thing that we have seen is that the approaches are varying provincially and quite differently, with different models, from private sector models to fully funded or full government models, which Ontario used to be, to hybrids of the two. And so we don't really know where any of that is going to fall. But we do know that what we can expect with respect to who's using, right, is that we've got 9 million cannabis consumers, most of whom are 44 years of age or younger. All right, so we know what the market is, although we do expect that older market, the old guys like me, are going to join or will penetrate the usage numbers. 24% of Canadian population have tried it in the last year. That would obviously have been illegal. We don't see 24% of the Canadian population in jail. And look at the number of people who say that they'll try cannabis after legalization. It's quite high. The real bulk of the users is between 15 and 44. That number of 15 is obviously troubling to the government, one of the reasons why they say they got into it. And then half of all current users are under age 35. What is interesting here is that, and if you look at the Colorado experience, you are getting people, the 18 to 24, 25 number is really where the majority of the use is. But you're going to get now expansion in the 25-year and older, which means that people who didn't use are going to be using, and they're the ones who are also going to be employed. So that's going to change in terms of where we think things are going. The current users are medicinal users, like pain and stress relief in the morning, and it also can include habitual users who are related to an addiction. Those, as Michael indicated earlier on, are accommodation issues that you're going to deal with. I actually don't think those are the problematic ones because you're kind of used to dealing with those from an alcohol perspective, for example, but there are accommodation requirements. The weekly users, and that's weekend or vacation, or just used for recreation, the real problem is, and this is where I think we've probably gone a little bit sideways, is there is a percentage of those people who are going to be in safety-sensitive environments. And it is beyond me why the government, the federal government, but even provincial governments don't say that safety-sensitive industries are going to have specific regulations with respect to usage. Now, we're going to talk about later how you can't measure that, but anything like heavy equipment, airplanes, trains, all that kind of stuff, why in God's name aren't there specific issues or specific legislation dealing with those safety-sensitive environments? They should be deemed safety-sensitive. I don't want my pilot high, right? Not literally, but figuratively, right? Or figuratively, not literally. Anyway, that's where we're at. So, Fiona, let's talk about what this actually means for the workplace.
Yeah, so the key issues we're going to dive into are workplace safety, disclosure and accommodation, privacy, discipline, productivity and discovery and use, and testing. When is it okay to test, and is this something that you as an organization want to start doing? Can we anticipate what will happen? So a lot of questions where people are talking about is, will there be more users than expected? Statistics on current age point to yes. Will there be an increase in addiction? If legalized casino gambling can be used as a guide, then the answer would again be yes. Will more employees request permission for medicinal use? Some current self-medicators will likely become authorized patients. And will courts and arbitrators change their approach? Currently, courts and arbitrators have focused on the obligation to disclose personal use and limit or eliminate at-work impairment. So right now, there's a significant amount of well-established law with respect to medicinal cannabis use, which can be used as a guide when crafting or updating existing workplace policies addressing recreational use.
And Fiona, because you do a lot of work with companies that are coming into the market as well, what we do understand is that the supply actually might actually be lower than a lot of that we anticipate. We may need more supply given the demand. What's your sense now, though, in terms of kind of for the economics of companies coming into Canada and looking at the amount that is available demographically to start up a business? Like, are you looking generally that there's going to be more producers that are coming into the market? So
there are a lot of producers right now. I believe the last time I looked, around 120 licenses have been granted. Health Canada is working at a pretty slow pace in terms of granting additional licenses. So there may be additional licensed producers, and I know we're having lots of clients contact us requesting assistance in terms of preparing those applications. I would suspect that a lot of people will still trying to be getting into that market. There's a lot of other opportunities. We're also seeing clients with respect to under their new legislation. There's now craft licenses that you can obtain, which permit producers to grow a smaller amount but are subject to less stringent security requirements. So I think we'll see industry participants trying to get into that space as well.
Okay, great. And remember, too, that the legislation doesn't deal with edibles, which it will at some point, and that's going to be a whole different issue. We'll probably be doing that next year at some point. So where the rubber hits the road for employers and why we're here today is workplace policies. What should they include when you're dealing with the use of cannabis in the workplace? Well, again, we go back to our history with respect to alcohol and other drugs and impairment in the workplace. It's not okay to be impaired in the workplace no matter what you're using. All right, and I don't care if you're sucking helium from a balloon or you're using cannabis. You still can't be impaired. So you need a clear and express statement that promotes safety and is to deter unsafe behavior at the workplace. This is really important because if you look at both accommodation issues and legal issues, safety is paramount. So if you can prove that, and we're going to talk about a case later on, that safety is at risk, all right, you've got a much better chance of supporting that policy, whether it's from an accommodation or non-accommodation perspective. We need a consistent prohibition on use, possession, and intoxication at work or workplace events. Now, you can't single out marijuana, but you can raise accommodation issues. So let me just briefly explain. If you've got a party and alcohol is permitted, you got to be really careful about what you're saying is not permitted. So if you're saying everybody can drink till they stumble out and take an Uber home, right? But you say you can't use marijuana, which is a legal drug, aside from any smoking issues, you may have a problem. Or you have a workplace policy that says people can go out and entertain clients by drinking, but if you're vaping in the parking lot, that might not be a good idea. So we need to kind of assess those and make them mesh. So we need, though, specifically to encourage and require, not just encourage, employees to disclose substance abuse issues without fear of reprisal. And the law on that is quite specific, which is, if you make it a requirement and they don't, that's a problem for them. If they do and you don't accommodate or you don't address it, that's a problem for you. All right? Avoid zero-tolerance-based policies because they don't consider accommodation issues, and provide for and set up a process for employees to ask for and obtain treatment. That stuff you probably already got in your policies, right? So your policies, maintain your confidentiality, a big part of this, all right? Set up a procedure for appropriate accommodation, which is following up and returning to work. And for all, look, our loyal listening base is HR-based. We understand this is more work for you, but we also understand that if you do it right at the front end, it's going to be less work at the back end. So you engage in training, education, and awareness with respect to your employees and keep records of all that. Distinguish between medical and recreational use and addiction. All right, that's important. If somebody's addicted, it's a disability under human rights legislation. Distinguish between discipline for breach of policy. This is a really big one, which we'll talk about, and accommodation. So if you're being disciplined, even if it's an addiction, if you failed to disclose under the policy, that's disciplinable conduct rather than disciplining for the addiction itself. All right? And if they disclose use or possession or it's found out, ask for the reason for use or possession to confirm if it's a breach of the policy, it's a safety issue, or an accommodation issue. All right? That's really, really a big deal. All right? So we're going to, on that point, we're going to set out a poll question right now. And the poll question is your workplace developing a cannabis policy? So please just click in yes or no, and we'll be able to show you the results very shortly. And one of the reasons why we're actually going that way is because we're getting a lot of questions from employers about, what do we do? And many of them already have a policy, and they're just now tweaking the policy to make sure that happens. All right, so let's just wait on the results a little bit, see if what we've got and see where we're at, and then we're going to move on to Michael to talk about the duty to accommodate, which is a big problem here. Okay, so there we go. We're at 70% yes and 29, almost 30% no. So those are pretty good numbers. You guys are doing a good job. And if you haven't got one, then you need to get one. Michael?
And part of that reason for developing a policy is because it does dovetail into, as Lorenzo pointed out, the duty to accommodate. Really, the policy is about providing the company and individuals, including HR, managers, supervisors, with confidence as to how they address potential intoxication issues and cannabis use, marijuana use in the workplace. It is really a grounding in which you can develop, one, a cultural position with respect to the company as to how they're going to treat intoxicating substances in the workplace and people subject to a disability or subject to an addiction or simply just misuse of those items, and giving them the confidence to challenge and question employees as they may appear in the workplace under the influence. Because recreational drug use, or even the general legalization of cannabis, is not a human rights matter. Employers are entitled to limit recreational use of marijuana. It's in the legislation, but it is your workplace. And you can prohibit impairment at work similar to alcohol or the use of any other legal drug or illegal drug. Employers can require disclosure of impairment due to recreational use. And in fact, the first step with respect to an individual who's identified either themselves individually because they've come to you, hopefully that's the best case situation, or you found them out, the first question you're entitled to ask is, what is your use based on? Is it based on a recreational use, or is it based on authorization? And if it's based on authorization, you have a right to ask for proof. So human rights as it relates to marijuana use is related to a disability. It's either directly related to the addiction, that is to the marijuana or to the drug, or indirectly because the marijuana is being used for treatment of another illness or injury, which is the main subject of the accommodation. It is not, however, for recreational use or admitted recreational use. So when we come to accommodation, where you're actually into that stream, either it's an addiction or it's related to another illness or injury, it requires the employee to provide disclosure and participate in the accommodation process. So they have to provide you with the medical information, medical support. You're entitled to prognosis information from the doctor, how long is the treatment going to last, what other opportunities are there in respect of accommodating at work other than use or continued use of the drug or influence at work. Is there options? If it's in respect of an addiction, then it's about time for treatment. You got to get this person to a treatment facility, and that may require this person to be off work. It may require that person to be off work without pay. There are other avenues that you're not required to pay for them while they're waiting to be treated. Your obligation is to keep their job available to them and have them return when they're safe to return to work. If this is used as a treatment in respect of another medical situation, then again, understand when is this being used, how long is it going to be used, when's the scheduling, and what's the level of impairment, and will that impact performance? Certainly you're going to have to review this person's job. There may be duties this person can perform shortly after the effects wear off. There may be situations in which the job, quite frankly, is too safety sensitive, and no level or even a moderate level of impairment is going to be prohibited.
Thanks, Mike. And if you look at managing the accommodation, this is a big part of what you're going to be required to do. But again, you guys have experience with this, right? You're used to managing accommodation issues, and in particular disability. You've probably dealt with substance abuse issues. You've probably dealt with alcoholism issues. You've probably dealt with other disabilities where people can't come to work on a regular basis without accommodation. So what do? Well, we have the same rules. We treat the employee's disclosure confidentially. We don't change just because it's cannabis. We're not allowed to advertise that somebody's using cannabis just because it happens to be a hot issue. All right? We're allowed as employers to get proof of authorization for medicinal use if it's a non-addiction issue. If it's an addiction issue, you can still ask for medical, confirming what the restrictions are, if there's any accommodations, or if treatment is required and what the length of that treatment might be. These are all things you're allowed now at law to ask for. Now, we've got some questions I noticed about, what about usage? If it's an accommodation issue or it's medicinal. How often they need to take the product. Will it be at work? How will they take it? Where will they take it? All those things Michael referred to as well. How long do they need to anticipate, and what are the side effects? These are all issues which you're required as an employer to ask in order to accommodate effectively. That doesn't mean somebody can pull out a bong and smoke it at work. All right, what that means is workplace smoking laws are still in play and in effect. All right, nothing's changed that provincially or municipally. Right, you may be able to say what are the other methods of ingesting. We don't want people smoking at the workplace, but more importantly, we can say that we're going to have to do an analysis of the job and say what are the impairment levels if you're actually using this at work. Because if you're a receptionist, it's one thing. If you're driving something at a quarry, it's a completely different thing, right? So we really are allowed to make an objective assessment of the effects limiting the employee's ability to perform his or her job and the modifications for accommodation. That's where the law is going to be taking us, folks, understanding that, all right? And that's where we get into the accommodation versus prohibition. We're going to require disclosure of permitted possession and or use of medical marijuana. That's one thing which we're going to ask for. All right? If the effects of medical use of marijuana, as with any other prescribed drug, impact the employee's ability to perform their work, that's important. Or if there's a current policy prohibiting use of possession of the drugs at work, they must confirm that they're authorized. All right? We're allowed to do that. And what if an employee discloses use or possession or is found out? You can ask the reason for the use of possession for use or possession to determine whether or not it is a breach of an established policy, a safety issue, or an accommodation issue. If it's not a disability, then it's recreational use, and you can look at that from a disclosure perspective. All right, so it's really, really important that we make those distinctions. Fiona?
Thanks, Lorenzo. Yeah, so safety considerations are going to be front and center. Health Canada's view is that cannabis or any cannabis product can impair concentration, ability to think and make decisions, reaction time, and coordination. Use also has an effect on motor skills and results in cognitive impairment. Use can, in certain circumstances, increase anxiety and even cause panic attacks. So there is a risk increased if an employee in a safety-sensitive position or a safety-sensitive environment is impaired by cannabis. So an employer can certainly say no, despite the demonstrated need for medical use in certain circumstances. And it will be a very fact-specific determination, including, if it's going to impact safety, if there's a bona fide job requirement of the position that just wouldn't be satisfied in the event someone was impaired. As much as an employer has a duty to accommodate, it's only to the point of undue hardship. There is certainly no carte blanche to smoke or ingest or get high on the job. And I mean, in certain circumstances, when an employee cannot be impaired even for medical reasons, due to the fact that they're in a safety-sensitive position or in a safety-sensitive environment, the employer's response should be very fact-specific, but may result in the employer saying, we're going to have to move you to another job for a period of time, or perhaps, if there's no other productive work, which is an unlikely scenario, but perhaps the decision would be, you're going to take a leave of absence for a period of time. But again, it would be very fact specific, and you'd want to do a significant amount of exploration before arriving at those decisions.
And it's an interesting point that the goalposts are going to move a little bit, both with respect to how we interpret all this, and the law is going to help us do that. But also, when you look at what safety sensitive is, what if we have a person who is responsible for planning processes in the workplace who may be impacted? What if we've got fund managers who are investing millions and tens of millions of dollars a year? That's not a safety issue, but it's a competency issue that we may look in terms of impairment. Now, we've never traditionally done that. We haven't said if you're suffering from an injury and are hooked to pain medication, we're going to kick you out of your job. All right? But these are all issues which are going to come into play, and I think Fiona raises a very good issue. Michael?
Ultimately, you're going to be faced with a situation as to whether or not discipline should arise, either because of a breach of a policy, a breach of your policy as it relates to a drug use or alcohol use in the job site, and impairment, or as a result of conduct because the person was under the influence. Again, this is a confidence issue. Discipline is not off the table simply because the individual has engaged in consumption of a legal product, where that now bleeds into the organization, or even in situations where the individual is suffering from an addiction, where they've taken steps outside of their normal employment obligations and engaged in misbehavior or misconduct that would otherwise result in termination or discipline. Discipline is still a tool in the toolbox, but you have to use it as it relates to the specific facts of the situation and consider them with respect to the specific facts of the situation, as Fiona pointed out. So, if this is an event where other misconduct has been engaged by the employee, but the employee's position is it's related to the effects of either alcohol or drugs, then you are entitled to determine whether or not that impairment was, or related potential disability, mental illness, and addiction was causally connected to the event. Did the person actually engage in this misconduct, theft, for example, because they were trying to feed a habit? Or were they simply taking advantage of the fact that there was an open cash till and they decided to take the money? And this was, and the addiction was actually just was an excuse. In those contexts, be process oriented. Understand that if there's a situation in which a disability is involved and you had advanced concern or may have should have made reasonable inquiry, you can still do so and determine whether or not you're in an addiction accommodation situation, because discipline should at that point be displaced by accommodation and treatment. You can again go all the same steps. Is there authorized medical use for it? Should the employee have disclosed? This is a big one, and one that's going to get larger with respect to policies and permitted use. That is, courts are starting to, and we'll talk about this a little bit later, courts are starting to come on board and say, if you are an addict, you have to come forward. It is imperative for the employee to put the employer on notice, and for the employer to have policies in place that then take that person and get them into the right stream of addiction counseling and return. Essentially, the threshold is being raised on employees to pre-disclose before you get into a situation where they're disclosing to after an accident has happened.
Good point. So, how do we handle impairment at work? And I've said it, and we've said it many times, you guys got this, all right? Because you've already been dealing with it in the past. Because in most cases, right, when somebody comes into work drunk, for example, you don't deal with it by having them blow into a breathalyzer. You deal with impairment. But I know what you're saying. You're saying, Lorenzo, we love you guys, but how do we deal with impairment? How do we measure that precise impairment? And the answer to that question is we don't right now with respect to cannabis use. Okay? But if an employee, that doesn't change the game for us. If an employee is still exhibiting signs of impairment from work, whether it's alcohol, drug abuse, including cannabis, right? You got to sit them down and interview them. And if there's concern about intoxication or impairment, stop them from working. Don't worry about, is it a suspension with pay or unpaid, or is it disciplinary right away? Get them out of the workplace, send them home in an Uber or a cab. All right, that's the first step. Safety is paramount. Don't undermine your obligations to ensure that the employee themselves and other employees are working in a safe environment. Then do your due diligence, right? Take notes from all people who interacted with the employee. What was the behavior? What did they do? When did it start? What happened? All of that. Was there, if it was a usage at work, was there an aroma? All those kinds of things. That can be evidence that you use down the road. Prior to attendance at regular work, interview them and ask them about what happened that day. Is there an issue? We need you to provide an explanation as to what happened. And by the way, if there's an addiction, we want you to self-disclose now, and we're going to offer you EAP. That is the best way to put yourself in a good position, not only to avoid legal liability, but to actually assist the employee, which is one of our goals here. All right? If they don't offer an explanation, no medical condition, no disability, no addiction, right? Then, as Michael said, we're going to go back and we're going to start looking at discipline and look to the arbitration cases, because they're dealing with these quickly, right? And that's exactly the way it's going. If an employee is not disclosing, then we're going to move back to the issue of culpability, and that's a big difference. So on drug testing itself, because I know this is a big deal, I'm going to let Fiona speak to that. Sorry.
Oh, yep. Okay. So a question we're receiving very often and almost on a daily basis is, should we start implementing a drug testing plan? And this is very common in the U.S. and more common in the U.S. Than it is in Canada. So with respect to drug testing, the law in Canada is quite restrictive. And when it comes to pre-employment and random, it's exceptionally limited. As a starting point, absolutely, it's only permitted for safety-sensitive positions. For random testing, the one of the only exceptions is really for the transportation industry, where drivers are transporting goods between the U.S. and Canada, and that's because it is a requirement in the U.S. So in order for organizations to be permitted to do these deliveries, it's accepted that their drivers are going to have to undergo random testing. Reasonable cause, post-incident, and part of a return to work plan are generally accepted as more permissive. So reasonable cause, this refers to, when an employee's conduct is indicative that they're under the influence. And a lot of our employer clients have been asking us to help prepare toolkits which assist managers in making this determination if it is likely that the employee is impaired. Similarly, with post-incident, after an accident, if there's a reason to believe that the accident was caused due to an employee being impaired, again, it's more permissive in that case. And then lastly, part of a return to work plan. So this is quite common where, an employee may have had an addiction, and there's been a number of cases where it's been determined that they've used and the employer has been working to accommodate them. But at a certain point, it's really, approaching the undue hardship point, and the employer will take the position that, perhaps we have cause to just let you go. Our duty of accommodate has been satisfied, but that said, we're going to give you this one last chance that you're able to return to work. But if you violate our policy again, that will certainly amount to cause. So when drafting a drug test, or when crafting a drug testing plan, it should be very fact specific, and it should be specific to your industry and your sector and the concerns with it. And as a very general guide, we've set out some basic factors that you should turn your mind to. And these are really just as a starting point of some of the factors you'll want to take into account.
Okay, thank you. That's very helpful, because if that's something that you're required to do, or you think you want to do, then I think you do need to get some assistance in just creating the framework of how that's going to be done and how it can be legally enforceable. So when we look at practical issues, this is the whole impairment issue, and we're going to be really honest with you about it. We have no way now of accurately measuring impairment. There are all kinds of companies, and particularly out of the United States, which say they can do it. None of that science is actually perfected right now, although I think we're on our way. Generally, under the Impaired Driving Act, it says 2.5 nanograms THC per milliliter of blood, but we don't know, because cannabis is so use specific, there can be different strains that stay in your system for longer. We don't know that, all right, and that's very important that we understand. There's a hybrid offense, fine and potential prison sentence depending on circumstances. So do we know? There's no readily acceptable level of THC. How will that impact us, and how reliable it would be? We don't know yet. But Michael and I were just talking before this, and we were talking about parents in the 70s. A lot of them were probably driving home when they had a little bit more alcohol, and Michael was joking that a lot of parents used to say it would steady them in driving when they had a few drinks.
Yeah, the issue here is going to be, and this is going to take some time, and we're being very frank here, both positively and negatively, as to what the level of acceptance is going to be and the acceptance of testing. It's taken probably a good, it probably took a good 20 years before roadside breathalyzers and what was accepted to be the level of impairment for individuals who are under the influence of alcohol to be accepted by everybody in the community, and designated drivers and what have you, took time. The benefit of getting a standard is going to be that everyone at least is going to know the playing field they're on. How much can I use? When can I use it? How long does it take to dissipate? However, that's also going to be there's a negative connotation to that. That is, if that becomes the accepted level, it may be too high for your workplace, but at the end of the day, courts and arbitrators may say, too bad. That's what's accepted by the public, and you're going to have to live with that in your workplace once that shakes out.
And remember, if you see some of the MAD commercials on right now, they're saying don't drive until 3 to 4 hours after you ingest marijuana, like at least, right? There's some commercials out there. I'm not sure that's accurate medically, to be honest with you. I'm not sure that even 3 or 4 hours is the right amount of time, but that's kind of what's being put out there. We're going to do a little bit of law on this because we think it's important. Fiona's going to deal with the Stewart versus Elk Valley Coal Corporation case.
Thanks, Lauren. So this 2017 Supreme Court case has been very important. So the Supreme Court of Canada reviewed the reasons from a lower human rights tribunal regarding the termination of an employee who had worked at a mine. The mine operation, as well as the employee's job, which was driving a loader, were accepted as being safety sensitive. The company had in place an alcohol and drug use policy pursuant to which all employees were expected to disclose any dependence or addiction issues preemptively, so prior to any incident occurring. The policy did not punish employees for disclosing any drug or alcohol addiction. Rather, the policy supported substance abuse treatment and return to work. This employee, Stewart, was involved in an accident with his loader, and a post-incident testing found out that he had cocaine in his system. So the employee then admitted to having used cocaine during his days off, and after the incident claimed that he thought he had an addiction. The employee had not, however, disclosed the use of cocaine or his presumed addiction prior to the accident, which was required by the policy. So after the incident and investigation, the employee's employment was terminated under the policy's no free accident rule. So this is a case that's helpful for employers. The majority of the Supreme Court of Canada agreed with the Human Rights Tribunal's conclusion that the employee's termination was acceptable under the policy. It was found that the employee's addiction had not prevented him from being able to understand the terms of the policy or disclose his addiction. So based on this decision, when we're reviewing policies that employers have in place or when we're helping them craft new policies, we're making sure, among other things, that the policies make it very clear that it contains this sort of no free accident rule, that the policies say it's okay if you have an addiction, we're encouraging you to come forward, however, and we'll support you if you do, however, you have to come forward before an incident.
Thanks, Fiona, and that's a really important case, and we're going to, a brand new case, which Michael's going to speak about, which has literally just been released in the last few weeks.
These are two decisions arising out of the Lower Churchill power development construction cases, and overall, the cases that have come out with respect to testing and use and disclosure, and in this case, accommodation, have all been very positive for employers. Positive in the sense of giving employers more tools to deal with these issues and confidence. And I think in part this is because that arbitrators in the courts don't like uncertainty. They don't want to be the person who puts a person back to work who may be dangerous, who may be compromised with respect to their decision-making capability, particularly in safety-sensitive situations. So this has all been positive. So you've got two employees. The commonality between the two employees is that both of them were in safety-sensitive positions in the construction industry. Both of them had actual pre-approval with respect to authorization for medical use of marijuana. Both of them were under a doctor's care, and both of them were utilizing the marijuana for a bona fide reason. In one case, the employee was found out without having actually disclosed his marijuana use and authorization based on smell of marijuana in his cab. And the other one, it was a pre-employment testing case, a permitted pre-employment testing case, in which the test came back for marijuana, and the decision was to retract the offer of employment. In both cases, the operation of the company essentially was upheld. That is, that they were both subject to accommodation, but the determination was that they couldn't be accommodated in the circumstances. That essentially the information was to them that the medical restrictions that they were under and the medical use as it combined with their obligations and the tasks that they would be performing, and not just the tasks they were performing, but where they were performing them in a construction zone, was going to prohibit them from actually performing any of their duties based on safety sensitivity. So this is where you get into a frustration issue. Ultimately, the decision may be that there is no job available. Either the offer needs to be retracted permissively because the person can't perform, or there's no other job or accommodation that can be provided, in which case the employee cannot return to work, and their employment is simply ended as it would in any other frustration issue, long-term disability, or other situation that doesn't permit that person's return to work.
Excellent. And remember, too, this is in the absence of actually scientific research with respect to impairment. But what the arbitrators looked at, and remember, there is lots of case law out there, and we can point you to that case law if you want us to, where the arbitrator in particular has held that if there is a safety issue, the obligation of accommodation is trumped. So, for example, if you've got somebody who may create a real health and safety risk to themselves or other employees, the issue of accommodation does not take the same predominance that it would in other cases. And in some cases we've read, it even says it doesn't even trigger the obligation to accommodate if there's a health and safety risk. So remember, health and safety is actually your friend here, and in this case it shows how important it is. So if we're looking at handling impairment at work and the lower Churchill decisions, right, I think what we take away is that your accommodation process should still be followed when you're talking about medicinal marijuana in respect to treatment of associated medical and physical restrictions or disabilities. All right, permitted authorization is not automatically accommodated in all circumstances. All right, we know that now from these decisions, and I think that's somewhere that the case law is going to kind of build on. And that the undue hardship considerations is the potential for several hours of residual impairment after initial use is a consideration. The level of use, the amount, timing, and duration is also a consideration, and so is the sensitive position of the work environment. Again, you got to look at the position. It also means, as Fiona said earlier on, it's a fact-specific inquiry. All right. So the current limitations on testing for present impairment works against the employer. In other words, what we're going to say is that we think this is a safety risk. We're going to try to switch the onus to say, well, how is it not? All right. And that's a big part of what we're doing. So what do? Well, review and revise your drug alcohol use policies. That's only 30% of you, by the way. So that's not a big number. And be prepared for application post-October. There's not going to be a magic date where everything changes and we're going to hear kind of, background noise and all of a sudden everybody shows up stoned for work. That's not going to happen. But what it does mean you need to do is review your accommodation policies and your process to ensure that you're compliant with the law and your obligations to accommodate to the point of undue hardship. But you're also reviewing these policies through the prism of safety and health and safety-sensitive positions. Make sure you understand how your organization is going to address legalized cannabis. And make sure that you're training about the policy, process, and investigation. Remember how we talked about how to recognize impairment? What's the protocol? What is the toolkit you're going to have in terms of dealing with those issues and dealing with any testing that you may want to implement? And train employees in the policy and its limitations, as well as specifically advising them, encouraging them on advanced disclosure. All right, really important that we start to do that. Okay? So one of the things that we have time for a few questions right now, and then we're going to wrap it up. But let's get into some questions. Michael?
So just to address some hot takes or some quick points. Somebody asked a question with respect to whether it would be beneficial for all recreational cannabis users to self-identify their use. With respect to pre-disclosure, particularly such a wide net, be careful what you ask for. That'd be like asking everyone in your workplace, has anyone drank alcohol or intending to drink alcohol in the near future? You're probably going to get answers from everybody. And everyone saying positive is not going to be helpful to you with respect to accommodation issues and for knowledge. When it comes to recreational cannabis, it's not an accommodation issue. So that's not about pre-disclosure. Pre-disclosure is about addiction and managing addiction issues. We've got a lot of questions with respect to, policies as prohibiting recreational use of marijuana. In these cases, your policy, as well as provincial and municipal restrictions, are your friend. So what's happening on October 17 is just the permissive use by the federal government as far as the controlled substance marijuana and cannabis is concerned. The actual sale and use is still provincially regulated. So that's why Ontario can raise the age to 19, 20, 21 and restrict medical marijuana use to only residences. In fact, municipalities are going to have the free rein to even restrict it even further. Plus you have the Smoke-Free Ontario Act. So all these can combine. So your policy should be about also your intention as far as a company. It doesn't have to say you don't use it at a club, because they can't use it anyway at a club.
That's a good point. We have some questions. There are a lot of questions here, but they all kind of focus on similar issues. One is we have the issue of aroma, right? Sufficient of impairment, and what actions an employer can take if an employee comes back from break with a strong marijuana smell. And we're going to go back to where we were before, which is how do you deal with this from an alcohol perspective? We know that many employers, no matter what the industry they're in, if somebody comes back and they smell like alcohol, that is a red flag. All right? Now, so the issue becomes, if somebody comes back and there's a smell of cannabis either in the workplace, that means somebody is using on the workplace, if you smell it in the workplace. If they come back and you smell it off their body, it might be a bit more difficult because they may have been around somebody who was smoking or using, if that's the case, so a little bit more difficult. But that's only evidence of what the issue might be relative to the rest of the impairment. If there's a smell in the workplace and somebody is using, I think from a policy perspective, we need to put out a very strongly worded note and memorandum saying you can't use it at the workplace. Anybody found using it at the workplace will be subject to discipline up to and including termination. All right? You're not allowed to do it. End of story. Whether or not you can use that as impairment, you still have to assess the individual based on those factors which we discussed. Okay? And that's really important. So this is only part of evidence. It doesn't show anything. It just shows that it may raise red flags that you have to address in the circumstances.
Yeah, we also received a question about whether accommodation in a workplace is necessary exclusively for those with medicinal licenses. So accommodation is certainly required for those with medicinal licenses. It will also be required when an employee has a disability, such as an addiction. That will also trigger the duty to accommodate.
And maybe one last question, what we had is respect of safety-sensitive positions and what qualifies as safety-sensitive and safety-sensitive workplaces. This is an evolving area in drug testing and generally as it respects safety. We are very positive and bullish with respect to addressing these things in the workplace and having positive policies and enforcement of policies. However, don't just jump to the conclusion that because an injury may occur in the workplace that you're automatically a safety-sensitive workplace or that your position is safety-sensitive. We're going to probably see an evolution of this as we discussed today, based on what is going to be acceptable levels of impairment and testing. You may get into a situation where permitted use and permitted impairment to some degree might even be okay in the workplace. And so you can't jump the gun simply because you have vehicles that may operate within your manufacturing center deems it safety sensitive. It's right now restricted to particularly construction zones, heavy equipment, trucks, trains, planes. It is not necessarily extended to those people working beside the truck, for example, or those who may be loading the truck in general manufacturing. So it is something that you want to deal with, but you should have safety as foremost in your mind because it'll help you enforce your policy.
Thanks, Michael. And there's another question that I think kind of hits the nail right on the head practically, and it says, for company-sponsored events where we provide 2 drink tickets for alcoholic beverages, or when our sales employees take out clients for dinner and drinks, what is the recommended approach for cannabis use when it's legalized? So, all right, so the first thing, let's break it down. It's not illegal to use cannabis. Now, I'm not sure we want a policy to say if you want to smoke up your clients, that's a good idea, and we think that you should do so. Where that hits, though, is you can't discipline somebody for using cannabis if you're not disciplining them for permitted use of alcohol. That's where the real issue is. I don't think we should address the issue of use of cannabis with clients. I think your policy remains the same, but I think your policy as it relates to discipline, right, needs to be considered when you're dealing with somebody who you say used it improperly. And I think you also need to understand that it may have differing impacts. And we've got some questions about people who are now driving home if they've used at work. Now, that depends on whether they've used it as an accommodated process or not. If they're accommodating by having to use it at work, we get confirmation from the doctor that they're okay to drive home afterwards. Right? That's part of the medical we're going to be asking for, because we don't want to be on the hook for letting somebody go home, even though that might not be the workplace for workplace safety and insurance purposes. So that's part of the information we can ask for. Okay? I think actually that we're a little bit, I think we've got about 5 minutes left. Are there any other issues that you want to address? I think we're good from our perspective. I do want to remind you, though, that when it comes to, and many of the issues deal with this level of impairment and what you can do on the level of impairment, you have to do your due diligence. You have to investigate. You need your information. Ask the people. Make the notes. Find out who saw what. All right? Then we come to a determination. Then consult with HR and legal if necessary as to what the appropriate penalty is. We have questions about, well, what if they don't answer your questions? Then you send them home. And you determine what you want to do, and that might be part of whether or not it's a disciplinary response. If they're not giving you information, part of your investigation as to whether they were impaired at work, you're going to go on the information that you have. What is that information, and will it sustain discipline in a union environment or in a common law non-union environment? All right?
And be prepared to ask questions and demand documentation. It is your right as the employer to get prognosis and understanding as to use. So if you don't need to rely on 1 or 2 sentence script notes from a doctor or authorized user saying this person is fine. You can do your due diligence with respect to that and understand and get confirmation from the physician or the health practitioner as to how this is affecting this individual. It may be a situation, in fact, that ultimately what the individual is taking is not actually the THC or narcotic, and there's actually no impairment whatsoever. It's, the smell and everything else is there as it relates to marijuana or cannabis use, but in fact, there's actually no impairment factor in there. You can get confirmation on that basis, and that is part of your accommodation process and part of the employee's obligation as their part of participating in their own accommodation.
Excellent. Thank you, Michael. Thank you, Fiona. And thank you all for joining us today. I thought that was a really kind of practical review and overview of what's going to happen. Again, we understand if there's more questions. If we didn't get to your question, we apologize, but we will be following up with this. I also want to remind you that the follow-up material will be sent within the next few days if you've registered for this webinar. So you're going to have this in hard copy, which you can use for your own purposes. We also want to remind you of our Workplace Law Summit, which is actually an in-person summit we do once a year. And this is being held in conjunction this year with Thomson Reuters. It's going to be at the One King West location in downtown Toronto. And you can see the topics that are going to be available. We would, if you're interested in registering, we've got the information up now. You can click the button. It goes from 8:30 to about 1:30 p.m. It is an excellent overview, an in-person webinar or seminar, and it will address a lot of the issues that are facing you from an labor and employment perspective, including cannabis in the workplace, but also with varied topics such as mental health, health and safety, harassment in the Me Too era, Bill 148, and legislative and case updates. So we do encourage you to attend and hope that we can see you then. And again, thank you for joining us, and have a great day on behalf of Michael, Fiona, and myself.